can the state discriminate between citizens on the grounds of religion, caste, sex or place of birth? Ans. Article 15 of the Constitution provides that no citizen shall be subjected to discrimination in matters of rights, privileges, and immunities pertaining to him. This article lays down 1. The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. 2. No citizen shall on grounds only of religion, race, caste, sex, place of birth or any of them be subjected to any disability, liability, restriction or condition with regard to a. Access to shops, public restaurants, hotels and places of public entertainment, or b. The use of wells, tanks, bathing ghats, roads and places of public resort maintained wholly or partly out of state funds or dedicated to the use of the general public. 3. Nothing in this article shall prevent the state from making any special provision for women and children. 4. Nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and scheduled tribes. Article 15 directs that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. Any law discriminating on one or more on these grounds would be void. The word only has been purposely used in the article. A discrimination based on one or more of these grounds and also on other grounds or grounds will not be affected by Article 15(1). It means that if one or more of the specified grounds is combined with a ground not mentioned in Article 15(1), the laws will be outside the prohibition contained in Article 15(1). Article 15(1) prohibits discrimination on the ground of birth and not that of residence. A state can, therefore, grant concessions to its residents in matters of fees in an educational institution. In Mainsavdas v. State of UP, A.I.R. 1953 SC 384, a law which provided for election on the basis of separate electorate for members of different religious communities, was held to be unconstitutional. In D.P. Joshi v. State of MB, A.I.R. 1955 SC 334, it was held that a law which discriminates on the ground of residence does violate Article 15(1). In that case, a rule of the state medical college requiring a capitation fee from non-Madhya Bharat students for the admission in the college was held valid as ground of exemption was residence and not place of birth. Place of birth is different from residence. In Balaji v. State of Mysore, A.I.R. 1965 SC 649, the Mysore government issued an order under Article 15(4), reserving seats in the medical and engineering colleges in the state as follows: backward classes 28%, more backward classes 20%, scheduled castes and tribes 18%. Thus 68% of the seats available in the colleges were reserved and only 32% was made available to the merit pool. The validity of the order was challenged by candidates who had secured more marks than those admitted under the order. Though qualified on merit, they had failed to get admission only by reason of the government order. The court held that the subclassification made by the order between backward classes and more backward classes was not justified under Article 15(4). Backwardness as envisaged by Article 15(4) must be both social and educational and not either social or educational. Though caste may be a relevant factor, but it cannot be the sole test for ascertaining whether a particular class is a backward class or not. Poverty, occupation, place of habitation may all be relevant factors to be taken into consideration. Article 15(4) does not speak of castes, but only speaks classes, and caste and class are not synonymous. The impugned order, however, proceeds only on the basis of caste without regard to other relevant factors, and that is sufficient to render the order invalid. The court said that the state was not justified in including in the list of backward classes all those castes or communities whose average of student population per thousand was slightly above or very near or just below the state average. Only those which were well below the average can be regarded as backward. Thus the main defect of the system adopted by the state was that under it 90% of the population of the state was backward. It was held that this was inconsistent with Article 15(4). Reservation of 86% of seats in technical institutions, such as engineering and medical colleges to the exclusion of all other candidates, if a single candidate from the scheduled tribes was available, would amount to fraud upon the Constitution. Clause 4 of Article 15 only enables the state to make special and not exclusive provision for the backward classes. The state would not be justified ignoring altogether advancement of the rest of the society in its zeal to promote the welfare of backward classes. In Guntur Medical College v. Mohan Rao, A.I.R. 1976, SC 1904, an important question arose before the court as to whether a person belonging to Christian converts, who originally belonged to scheduled caste, on reconversion to Hinduism can claim the benefit of reservation of seats in a medical college under Article 15(4). The court held that a person whose parents belonged to a scheduled caste before their conversion to Christianity can, on reconversion to Hinduism, be regarded as a member of the scheduled caste only if he is accepted as a member of that caste by the other members of the caste. On such acceptance, he would be eligible for the benefit of the reservation of the seats for scheduled caste in the matter of admission to the medical college. In state of MP Nivedita Jain, A.I.R. 1981 SC 2045, the Supreme Court upheld the validity of an executive order of the government of MP completely relaxing the condition of qualifying marks in the pre-medical tests. The court observed that in the absence of any law to the contrary, it is open to the government to impose such conditions as would make the reservation effective.